Hey everyone, and welcome to Private Podcast, where we plug in and explore the intersection of privacy, human rights, technology, and democracy. I'm your host, Derek E. Silva, and today we are speaking with Jim Harper. Jim is a visiting fellow at the American Enterprise Institute, or AEI, where he focuses on privacy issues and select legal and constitutional law issues. He has served as counsel for the Subcommittee on Commercial and Administrative Law of the U.S. House Committee on the Judiciary and as counsel for the Senate Committee on Government Affairs. Nothing like government names to give you a sense that you're doing just fine in life. More recently, he worked at the Competitive Enterprise Institute and the Cato Institute, which I think many people will know of, where he wrote on the intersection of business, technology, and public policy, including privacy, surveillance, data security, telecommunications, and cryptocurrencies. Jim, thanks so much for taking the time to be here today and to listen to that lengthy but very deep profile on yourself.
Nice to be with you, Derek. Thanks for having me, and thanks for rattling through all the stuff I've done.
Jim, thanks so much for taking the time to be here today. We really appreciate you doing this.
My pleasure. Glad to be with you.
Thanks. So let's start here. What is AEI?
AEI, the American Enterprise Institute, is a think tank, and that's an institution. They're quite prominent in Washington, D.C., though there are others in U.S. state capitals and some think tanks all around the world. The way I put it is they're dedicated to building social capital institutions, not organizational institutions, but institutions, ideas. The ideas that maintain our society, the ideas that maintain our democracy. Many think tanks have an ideological bent, and AEI is perceived as being center-right, and I think that's probably fair. So our job at a think tank like that is to produce ideas, to talk about current events, to research deeply into political theory, philosophy, whatever it may be. People in think tanks work across the board on all different aspects of, again, building social capital or maintaining the social capital that makes our societies work.
Terrific. Thanks for that introduction. Can you tell us a little bit about your fellowship at AEI? Do you have specific areas you focused on in researching?
Yeah, I'm nominally working in technology policy, but my background is in law and specifically constitutional law. So I kind of bring those two together. I work, as your introduction suggested, I've worked on a lot of different policies. I'm primarily focusing on privacy, which remains a challenging issue. I tend to focus on privacy sort of sociologically, what it actually means, what the word means, what people are talking about, the values they're talking about when they want to protect privacy, but also the legal issues, and in particular, Fourth Amendment type issues in the United States, where we're supposed to have quite strong protections against government encroachment on our privacy through the Fourth Amendment. So I do a lot of work on Fourth Amendment and its application to data in this burgeoning modern age.
What comes up the most often when it comes to values around privacy? You mentioned different people have different values. What do you hear are the most common most common refrains when you're talking to people about that topic?
Well, it's interesting because I think I've found that there are at least 8 different things that people are talking about when they use the word privacy, and I'm continuing to dig into what people really mean. The main sense of the word, I think, is control of information about yourself. When you want to keep some information from others, share with others, decide for yourself how you portray yourself to different audiences. Commercial, social, governmental, whatever the case may be, controlling information about yourself. But fairness is also a privacy issue. We have privacy laws in the United States that also really focus on fairness. The Fair Credit Reporting Act, for example, people talk about it as a privacy law, but its real focus is getting people fairness. Autonomy. In the U.S., we have a series of Supreme Court decisions that called privacy, named as privacy, the right to make decisions about procreation and birth control and that kind of thing. There's also, I'll probably fail to remember all that are on that list.
That's okay.
Being left alone, just peace and quiet is a privacy value. Financial security is another thing that people are talking about when they say privacy. That is essentially being protected against identity fraud, but also personal security. A lot of people use husbanding of information about themselves to protect themselves. That is, particularly people with abusive ex-lovers or spouses. They need privacy, or they need to control specific information about themselves in order to protect themselves. So all these different values, I've dropped one or two here, trying to describe them. These are all privacy values, and I think it's important to understand which one you're talking about, especially if you're going to be doing legislation or regulation to try to improve privacy. You need to know which one you're getting at, and then maybe you'll be able to tell whether you've done a good job or not.
Right. Fair enough. Thanks for explaining at least most of them. I think you got about six there out of the eight, so that was good right off the top of your head. Um, Conversely, where do you think are some of the most critical challenges to protecting privacy, depending on the situation you're talking about, or the value, as you put it, and fair information, which is a term you also used.
Yeah, well, I'll give you two answers, which is a vast oversimplification. One really refers to privacy in the commercial and private sector, and the other is privacy vis-a-vis the public sector.
Mm,
Our main challenge in the private and commercial sector is understanding how information moves. If you draw a broad parallel between how information has always moved up until 20 or 30 years ago and how information moves now, it's really, really complicated and difficult. But most everyone raises their children saying, keep your pants on, that's your private area, and just naturally learn how clothes protect your privacy. Going inside your house protects your privacy, and so on and so forth. So we've all grown up knowing how to protect privacy in the physical world, and it doesn't seem very difficult. And there are lots of social and cultural mores around information hiding and information sharing. We're quite used to them because we do grow up with them. The online environment is, I used to say, all new. It's getting to be a little bit accustomed for people, but it's really an all new environment, and so people don't know that when they log on somewhere, there's an IP address that they must have in order to receive the data they're downloading.
right.
That's trackable. All kinds of aspects of the browser make them trackable. All the identifiers they use online, um, from usernames to various other codes that they might think they're using to hide themselves from others. Well, those are all pretty well trackable. So it's very, very hard for people to understand how to protect privacy in this environment. For me, that makes it a generational problem,
Hmm.
and the next generation, the rising generation, will have a better sense of how information moves and how to protect privacy. And the generation after that, they'll be as conversant with the online world as we are with meat space, with walking around in town. Then in the governmental sector, I think the main challenge is um, maintaining the authorities that protect privacy. The Fourth Amendment in the United States protects people's privacy indirectly. There isn't a right to privacy per se, but that right against unreasonable searches and seizures of our persons, houses, papers, and effects means, or should mean, if I'm successful, will mean that we can protect privacy against government just as we protect privacy against others in that commercial space. So it's access to data about our movements that might be housed with a telecommunications provider, access to data that maybe that is on your Fitbit or has been uploaded from your Fitbit, or whatever the case may be. Putting legal protections in place that allow us to protect privacy of that information against government investigation is the other sort of major challenge for protecting privacy.
Terrific. Thanks for that. Only because you mentioned it specifically, Fitbit was recently acquired, or maybe not so recently, but in the last little while, was acquired by Google, and I think part of the approval with either the U.S. or the European Council, the European continent-wide government, was that they had to promise in writing that that Fitbit data would not be used for advertising. So that was certainly an interesting situation where Google was had Google Health already, or Google Fitness. I'm not sure. I think it's called Google Health. An app already on their devices and on Wear OS devices, but obviously we're about to wanted to acquire this massive ecosystem with even more data um, that already existed. And I think a lot of those people who bought a Fitbit at least in part because they knew it didn't belong to Google or to Apple or to Facebook. It was an independent firm, which had also acquired Pebble before that. So now you have a small company being acquired by a slightly bigger company, being acquired by a much bigger company, and a lot of data coming and software and all sorts of other things coming along the way. So that was, one recent case where that exact issue really came to the fore. And it was an interesting precedent on how to appease governments, at least on what would happen with that data, at least in the short term, if not forever.
Yeah, and you remind me that one of the other dimensions of privacy for people is a sort of concern with commodification.
Mm-hmm.
That is everything about your life being turned into a commercial opportunity. I get that. There are parts of life that should be held apart from commerce, but technology is making commercial opportunities more available in health, for example.
Yeah.
That's concerning to some. Others sort of embrace it as an opportunity, but it's a value that some people have. And yeah, actually, the one of the notions I try to press is that promises about what will happen with information are contracts, and they should be enforceable as such. So your terms of service document, your privacy policy, I think those should be more clearly recognized as contracts. Many courts have, but many people don't think about it that way, and it could be that the compliance folks in a lot of companies don't think about it that way. And I think contracts, even contracts that deploy property, personal information as property, giving some rights to the information to the platform and other rights to the information to the consumer.
Mm-hmm.
The right to exclude is thought of as the essence of property, that is, keeping other people off of your land or away from your car or out of your books. That's the right to exclude.
Right.
I argue that these terms of service statements and privacy policies give the right to exclude almost entirely to the consumer, which is good privacy protection, some use rights and some exceptions that are necessary for, checking to make sure the services work and responding to legal process and to protect people if there's an emergency, dangerous situation, whatever the case may be. Those, you can look at those privacy policies, think of them as contracts, and think of them as allocating property rights. And then you do that, you end up with a stronger system for privacy protection along several different margins. One is that it's harder for the government to take that information, sweep in and ladle it out of corporate stores. Also, I think culturally, compliance folk in companies recognizing that they're dealing with someone else's stuff, not just our data that we get to do with what we want. And oh, by the way, we've made these promises over here. What, are we serious about that or not? No, those are contracts. It's their property. You're stealing something from them if you do something that is inconsistent with your contract. Now, a lot of companies are bad at even following the rules they've laid down for themselves. And the Cambridge Analytica scandal, Facebook, is a good example of where they're not terribly competent. So I wouldn't say that this being property allocated by contract fixes everything, but hopefully culturally you'd get better, more straightforward, more serious compliance by regarding personal information as the property that's shared between the platform or company and the consumer. So I poured a lot out there just now. You pick whatever you want to follow up on.
Yeah, no, I'd actually like to find out from you if you know of any organizations that are doing that well, like a terms of service and a privacy policy. Somebody with an average reading level, which let's take newspapers for example. I heard once that they were written for like a grade 6 reading level, which means my oldest kid should be able to read a newspaper just fine. Assuming that's true, do you see anyone out there or any organizations out there putting together terms of service that is fairly plain language and actually a reasonable length and similar for the privacy policy?
Well, no, and it would take a heck of a lot of research to do that. But I think you have a premise. It's a common premise that people must read them in order for them to be taken seriously. And I think the way it works which is the same as contracts across the board or deals that we make across the board, is that there are some fundamental parts of the contract that you know about and you think about. When you go to the grocery store, you look at the price of bread and you expect to walk up to the counter and that's going to be the price that they charge you. The exchange is I get bread and I pay this much. We know that much.
Yeah.
Same with use of a platform. I'm going to use this platform. The fine print is not something that we all review. We don't review it when we buy bread. We don't review it when we start to use a platform. But some people do. You get privacy advocates, you get lawyers, you get oversight officials in government looking over these things, and occasionally you spot where some policy has gone out of bounds. My research hasn't been able to turn it up, but some years back, AT&T had a term in one of their policies that anything traversing their network became their copyrighted material. They owned the copyright to anything going across their network. Somebody found that, pulled it up. It got all kinds of news, and that term was gone right away.
Sure.
And that's more like how these contracts are negotiated. They're negotiated sort of in bulk, in whole. I don't even agree that that the language that's offered by the platform in that terms of service statement or privacy policy is binding. It's a suggestion, and if it turns out to be reasonable when these things are hashed out, that's the actual contract. That's old style common law contract doctrine, which is that there must be a meeting of the minds between two parties, and where there's not a meeting of the minds, some subject matter that was not covered by either of them, you go to what's reasonable in that particular industry, or what's reasonable in that type of relationship. So the privacy policies themselves are suggestive. When push comes to shove, the meaning of the policy might have to be tweaked toward what's reasonable. And that's just actually basic, like I said, old style, common law, contract interpretation. But I think it's stronger to have that than to have privacy policies as statements that aren't contracts that some regulator has to come in, if you're lucky, and decide to pursue a company. I'd rather have it done in a more decentralized fashion, consistent with the legal doctrines and regimes that we know well.
Yeah, sure. And that's fair. And I think we've actually seen court cases in the US, I think a few in Canada, the UK as well, where that's basically been what happened, where somebody brought a case to a court against some sort of organization, and portions of the terms of service have been more or less stricken down. I don't recall a specific example off the top of my head here, but I know I've read in the news or heard on a podcast, a news podcast I listened to, the fact that this section of terms of service has been deemed to be egregious, and there's no way a reasonable person would have read this 50-page terms of service or privacy policy or end user license agreement, or EULA if you prefer. And therefore, you couldn't actually expect the end user to abide by it because it was buried on page 47 out of those 50 pages. And even the judge themselves say, like, I just scroll through and hit agree because that's what I need to do to get to the next step. So that AT&T situation is really interesting. I'm sure Disney and a bunch of other rights holders or IP creators were thrilled to hear about that provision. That's funny.
Yes, yeah, probably so. It's yeah, and one of the issues in this area, you see, I think a lot of people focus on, in the U.S., for example, what the Federal Trade Commission is going to do about the latest scandal, but at the same time, some issue breaks out. You see that class action lawsuits are filed, where the millions or even billions of people who use this particular platform were alleging that they were harmed by this practice or the other. It's another form of keeping. It's another form of this debate about how information is supposed to move and what the rules are supposed to be. And consumers learn through these things. Governments learn through these things. The companies themselves learn through these things. I think it's worth highlighting that they don't even know. We regard the companies as somehow like they've got to be the experts at all this stuff. A lot of them, I think, don't quite understand all they're doing. Don't quite understand the consequences of all they're doing. and what could be harmful and what could be good. They focus on what's great about their products, right, and forget to think about what could go wrong. So everybody's learning. Everybody's kind of feeling along in the dark, and the lawsuits that come are part of that process of learning about how things are supposed to be. One of the challenges, of course, is that privacy violations don't have very much in the way of traditional damages.
Right.
The damages rule in common law is that there has to be, I think it's really there for administrative purposes, there has to be something happen to you that you can prove. You have to have lost money. You have to have some kind of physical injury you could show to people. You have to have mental suffering so great that it has a physical manifestation. So it's really a question of how do you prove this stuff?
Mm.
If 100 million people had some iota of information about them released, what are the damages? We want them to get that protection, but the damages when a small iota of information about many, many people is released are not very great. And so I don't think we necessarily need to come in over the top and say, well, we've got to fix this problem some other way, because literally the damages aren't very great.
Right.
Perhaps there's a market remedy that the company that does that takes a lot of heat, spends a lot of money on PR, loses customers by some margin, loses new customers by some margin. There is some cost imposed on companies that make privacy errors, even in the absence of any legal action or any regulatory action. I'm not saying there should be only a market response, but the market responses, the private law responses, that is class actions, contract actions, whatever the case may be, and then public responses like regulatory bodies. All of those are part of the process of figuring out what wrong is the serious wrong and what wrongs are trivial wrongs and all this stuff. More than enough to try to figure out, and we won't do it in the short term. It'll take a long term horizon to figure out right and wrong with how information is used.
Yeah, fair enough. Um, I think I want to skip a little bit ahead here and talk about the Bitcoin Foundation, or the BTC Foundation. What's that organization all about?
Well, the Bitcoin Foundation is easiest to talk about in the past tense. I think it still exists, but it's not terribly active anymore. That was a group that came together in the early years of Bitcoin, just 5 or 6 years ago, to try to promote Bitcoin and protect Bitcoin and lend to its credibility, help build the technical foundations. The foundation had a few of the most prominent conferences in 2013 and 2014. Now there's a huge cryptocurrency conference circuit, but it helped bring together some of the real early movers. I joined the foundation after sort of working with them informally for a while in 2013. I joined the Bitcoin Foundation in 2014 as their Global Policy Council, mostly working in Washington, D.C. and Brussels to teach people about what Bitcoin is and how it works, and give folks someone they can call if they have questions, try to start to parse out some of the regulatory issues that were coming. The foundation itself, now essentially defunct, thrived during the run-up in price of Bitcoin in late 2013 because it had a sort of endowment. Natural early gifts became an endowment. It didn't really build a fundraising operation. So when the bottom dropped out through 2014, ironically, an organization dedicated to a new form of money ran out of it. And so the Bitcoin Foundation has, it was controversial at the time, and it's been superseded by a lot of other organizations and efforts. And now, of course, there are many, many different cryptocurrencies.
Right.
Many of them are backed by foundations or other nonprofits that sort of help to develop them. Bitcoin doesn't really have any major foundational support, but obviously it has the most awareness and understanding. There are a lot of people working on all of these different cryptocurrencies and all the different dimensions of building a cryptocurrency and ingratiating it into society. I think that's the most interesting thing. That's the area that I focus on, is you can take a technology and put it out there and nothing happens.
Right.
It really hasn't done anything unless you weave it into society somehow. So look at the World Wide Web, for example, or TCP/IP with the protocol that everything runs on. You could invent that and stick it out there, and if nobody picked it up and used it, it doesn't do anything. And so I think that seam between the technology and the usage is the fascinating area. That's what that's what the Bitcoin Foundation, I think, was supposed to do. Didn't really succeed at it, but it was a great run to be involved with the foundation and to be involved with Bitcoin at the time. I'm still fascinated by cryptocurrency, of course.
Why was this important to you to get involved with the Bitcoin Foundation and apply your legal and policy background to this new paradigm, Bitcoin, cryptocurrencies, and across the Bitcoin Foundation?
Well, Bitcoin, at the time there was only Bitcoin, uh, brought together all these threads of interest of mine from cryptography, not necessarily a strength, but I was interested in cryptography, open source software development, privacy, financial privacy in particular, monetary policy, again, not an area of my expertise. And, there's really tremendous, tremendous potential in this technology. At the time, I was fond of saying that it'll be 5, 15, or 50 years before the potential is reached. And obviously, it won't be 5 because it's been more than 5 since I was saying that. It could be 15, but maybe it'll be more like 50. But cryptocurrencies and blockchain can render tremendous changes, and I think for the good in our society and how it works. There's a lot of political Sturm und Drang about it, and ideological Sturm und Drang, if I'm saying the phrase right, Sturm und Drang. Um, but there are a lot of institutions that could be replaced by software, and a lot of interactions that are somewhat coercive or the powerful versus the weak, big banks, big governments
Yeah.
versus consumers and citizens. Those could be radically transformed into a more equal, more voluntary, competitive, if you will, society. Competitive because service providers of currency, let's say, might compete with one another for which provides the best, that serves the best for different purposes. All kinds of
Right.
record keeping systems, from property systems to identity systems and others, are centrally controlled, but they're really about our stuff, whether it's our identity or our property. And if those were to move into systems that were controlled across the globe by voluntarily joined organizations, what a tremendously different society we might have, and the potential for growth and improvement of human life is really incredible. It doesn't look like it from looking at cryptocurrency right now, and the way the particularly crypto Twitter looks. It's pretty ugly, but it's a very, very strong technology, and I'd like to see that potential reached.
Yeah, I'm not going to comment much on crypto Twitter. I'm kind of outside of it, regardless of my place here in the cryptocurrency industry. Um, Certainly, I don't get involved. I don't get involved in any pissing matches with one blockchain versus another blockchain, or one stable coin versus another stable coin, or two different technologies that serve similar but not quite exactly the same purposes. I'm very happy to help draw those lines for people. Be like, yeah, these two things are similar, but here's how they're different, and both of you should just chill out, like really, because I don't think, perhaps in contrast to some of the extreme capitalism we've seen in all sorts of places, I don't think it's a winner take all industry by any means. Certainly not if you get 7 or 8 billion people actually using blockchain technology in their daily lives, whether it's for payments or savings, or borrowing, lending, all these financial tools that have become quite popular since, or in the last year and a half, but have been around since 2017. And I know because I participated in ETHLend's initial token offering back in the fall of 2017. So they've been around for quite a while, um, which is now Aave, for anybody for any of the uninitiated. And and then of course NFTs has really brought a lot of this, non-fungible tokens have really brought a lot of this to the fore for all sorts of people, whether it's things like NBA Top Shots, uh, or Beeple, Mike Smith, I think his name is, Beeple's auction through Christie's, making him millions and millions of dollars, and I'm sure the big tax bill as well, but that's his problem. And I hope in the end leads to greater decentralization, or the use of the decentralized versions as well, as any CBDCs. Mostly because I personally, I'm really concerned about the privacy implications for a digital yuan, a digital US dollar, a digital Canadian dollar, and how that money is rolled out. There are still benefits to that, I believe, um, especially for helping end homelessness, and all the social services that those individuals need in order to get them off the street, get them into a home, get them the medical assistance or mental health assistance they need, and then get them off, get them self-sufficient again, which I'm incredibly confident, 99% of people with temporary or long-term homelessness, mental health issues, etc., want to have. They want to have agency, but a lot of the current systems in place don't afford you that, without constantly, literally being at somebody's till, begging for the next bit of assistance that you're supposed to be getting anyway. These sorts of technologies can really help speed up solving a lot of humanity's problems, if we literally just let them. There's all sorts of details, obviously, that need to be worked out, but I'm definitely on board of with you in terms of these technologies really pushing things forward, making things more fair, and removing a lot of unnecessary legal rigmarole or paperwork or what have you, and organizations that can be replaced with software, as you mentioned earlier.
Yeah, the I'm involved with the Digital Dollar Project here in the U.S.,
Mm.
which is one of the efforts to advance the idea of a CBDC. I'm nominally their privacy expert, or one of the people that has a focus on privacy there, and that's a real problem. It's going to be a real challenge to try to do. It's a challenge. It's more of a challenge in Bitcoin than we realized at the outset. I thought it was pretty private, but it's pretty trackable.
Yes.
And
As we've
and
recently
same,
discovered.
it was in the early in I also thought Bitcoin transactions were free, and they're clearly not free. But still, tremendous potential for low cost financial services, and potential for versions of cryptocurrency like Zcash and Monero maybe showing the way to doing private transactions.
Yeah.
The CBDC debate in the U.S. is very much about, like it's inspired by Bitcoin and inspired by the privacy potential in cryptocurrency, but it's also very cognizant of the financial regulatory superstructure, the financial surveillance superstructure. And I think there's a real challenge. There's sort of going to have to be a real reckoning with an American CBDC, or I should say a U.S. CBDC, to reconcile the technology with the constitutional values. I spoke about the Fourth Amendment earlier. Both the Fourth Amendment and due process rights have to be protected within a CBDC, not just by policy. They have to be protected by the technology, so that it isn't just a big trove of data that government agencies or corporations can dip into whenever they want. So that stuff can be built. It's not really a technology problem, but getting having a policy that embraces a truly private technology is going to be a real challenge. So we'll see what happens there. I'm not anti CBDC. I think a lot more could come from the fully competitive cryptocurrency environment. And what I'd love to see there is more backfill of social capital. I mentioned that think tanks produce social capital for society, and that backstop our institutions. I think the cryptocurrency technologies have vastly outstripped the social capital that needs to backfill, so that people understand how they work, so that there's broad understandings of the economics, of how the technology interacts, how people use them, and there's so much backfilling that needs to happen, so that people actually know in debates about a particular fork on a chain. They can make good arguments about why you should follow my fork of the chain versus their fork of the chain. That's not there at this point, in particular in Bitcoin, where there has been a lot of brigading and tribalism and everything else. I'd love to see in that community and all the others much more articulation of why this technology serves this use case the very best. Lots to do to build out that society so that we get there in more like 15 years rather than 50.
Yeah. Two questions. One about FinCEN and the Canadian version FinTrack, and the CBDC, and then I want to come back to the AEI and maybe how organizations like that one maybe potentially do backfill that social capital. Do you think? I guess I don't know if this question is about your opinion on doing so or about the feasibility. You can take your pick. At least here in Canada, transactions over 10,000 are supposed to be reported to FinTrack, the financial. I don't know, our version of the anti-money laundering system that all the banks have to participate in and all that. So if I send somebody $20,000 or something like that, that transaction is reported to FinTrack. I'm pretty sure the U.S. has something similar. I don't know if it's 10,000 U.S.
Yep.
or whatnot, but transactions like that need to be reported to FinCEN. Could that be baked in to a CBDC blockchain or distributed ledger? And do you think it should be? Would that help? And do you think people would be okay with that?
It could be baked in, and I don't think it should be.
Oh,
I'm thinking back of many years ago. I had the privilege of speaking to a group at the U.S. Treasury called the Bank Secrecy Act Advisory Group, which is government officials and representatives of banks and other financial institutions, and they wanted to hear a privacy perspective. And I gave a nice talk of where I, sort of tried to lay out what privacy is, that sociological stuff, and all, many different dimensions. And I sort of concluded the last couple of minutes of my talk where, and by the way, pretty much everything you do is unconstitutional. They didn't invite me back, strangely. Really, this is monitoring of people's financial activities without any suspicion,
right.
And I believe that's contrary to the Fourth Amendment, which requires you to have some level of suspicion, indeed probable cause and a warrant, to get access to people's financial information. But this superstructure has been built up over the last 50 years since the Bank Secrecy Act was passed in the United States, and through the auspices of perfect. I'm blanking on the name of the European organization, FATF, the Financial Action
Yes.
Financial Action Task Force.
Right.
FATF in Europe, that sort of coordinates all the countries on their financial surveillance programs. I don't think it actually provides good security. That is the gating factor on terrorism is not access to money. So their adoption of terrorism as their purpose after September 11th, 2001 was window dressing. I don't believe in the drug war, which is a large part of what this kind of financial tracking is for.
Yeah.
And frankly, I'm in favor of tax avoidance, not violating the tax laws, but if you can work to lower your taxes, that means as a business you can provide your services to at lower cost to your consumer. You can pay your people more, and your stockholders get more too. So I'm not on the team with FinCEN and most of the work of the Bank Secrecy Act in the U.S. So it could be built into a CBDC. I'd have a big problem if it were to be built in. Well, the modest or compromise position I've taken, which is still rather preliminary because there's so much more to learn yet, is that a CBDC infrastructure should be able to support all policies. The base, if you will, if there should be a base layer that can do anything.
Sure.
The base layer would allow for full anonymity in transactions. It would allow for reporting of transactions at a certain level. It would allow for whatever the policies are that are out there. The technology should be able to support them all, so that the technology doesn't end up driving the policy.
Mm-hmm.
I do think that the bottom is falling out from under the Bank Secrecy Act. You've had it questioned in the U.S. Supreme Court. The third-party doctrine is the Fourth Amendment doctrine that has allowed this kind of financial surveillance. It's been openly questioned in the Supreme Court, and eventually there will be a case coming to the court where the court says this does not work. In this era, we cannot say that you have no privacy interest in information shared with a third party, because then you have no privacy interest in any of your communications, in any of your finances, in any of your health information. It's a hollow shell. The third party doctrine and the Bank Secrecy Act will fall at some point in 15 to 50. So a CBDC infrastructure has to support the new era of privacy that we'll have after that law is struck down in the U.S. and hopefully other countries around the world follow and regard their citizens as largely law-abiding and not subject to surveillance just because they transact.
Um, we talked a little bit about AEI at the beginning, some of the things you do there. I think we've touched on enough stuff that I actually want to come back and say, ask you, how does AEI help to advance these ideas that are rooted in the belief of democracy, free enterprise, American strength and global leadership, and solidarity with those at the periphery of our society, or at the very least, these ideas that we've been talking about today.
Well, AEI is a special institution because it hires people to defend good ideas,
Hmm.
to produce new ideas, to challenge old ideas, and it's a special time in history that we live in where really ideas end up being powerful. Most of history has been run by the powerful preying on the weak, whether that is prehistoric times where it was just sheer brute force, or in our the early history of mankind where it was kings or lords or whoever. We're in a time where the good ideas are the ones that prevail. So we were very proud of the U.S. Constitution, flaws and all, and other Western governments around the world are largely uh, responsive to this idea of democracy, and um, helping to build those ideas, build on them, defend them. That's essential work, and it's important work. It's work that I'm excited to do at AEI. I'm excited to have colleagues who work on issues with me in tech policy, who work on economics, who work on so many different dimensions of our society. So it's not like a factory that builds widgets and at the end of the year you can count up how many widgets you built and how much profit you made.
Yeah.
But I think it's an essential institution, and it's an essential type of institution because of what it does, which is to help make the great ideas that underlie our society better, and defend them from the depredations that are out there, the bad ideas that gain currency from time to time. So it's exciting work, and I feel privileged to be at AEI and to be able to do the work that I do.
Cool. Thanks for that. Um, Going a little bit forward here, and maybe on some slightly or different takes on some other topics. Um, we've seen, I think, some people flipping from making this statement that I'm about to make, or ask you about, towards no longer believing that. Kevin O'Leary, which is a, for better or worse, Canadian export to the U.S. I'm sorry, Mr. Wonderful is not actually that wonderful in my opinion. Um, he's no longer on this train. But what would you say to the people like that who believe that Bitcoin has zero intrinsic value, or like I said, he's certainly made some controversial statements around that fact. He doesn't seem to believe it anymore, but there are still people out there who do.
Well, the problem with statements about intrinsic value is that nothing has intrinsic value. The subjective theory of value is that everybody values things themselves, and that prices are the product of the mass of subjective valuations. So when you say something has intrinsic value, you're mistaken. A sandwich has value if you're hungry. It has none if you're full. A bar of gold is very valuable if you're near a bank or among gold traders. It does nothing for you if you're on a desert island. That's the sort of the sort of simplistic case for the subjective theory of value.
Sure.
But you get a
I
lot
guess
of
it might
folks.
be useful if you're trying to put yourself out of your misery then, but yeah, otherwise
Well,
it's
there
not
you
going to do
go.
much
You've
for you.
got you've put a valuation on that bar of
I
gold when you're
did,
alone on
yeah.
the island. um, so basically, anybody who makes a statement that Bitcoin's going to go to the moon or going to go to zero is probably off by quite a bit.
Hmm.
But the statement about whether it has intrinsic value, I think, is flawed in theory.
Okay.
The question is whether people will continue to value it. ultimately the value and thus the price of Bitcoin or any cryptocurrency is going to be based on its utility to people. That brings us back to that idea of integrating or ingratiating a technology into society.
Mm-hmm.
The winner will be the one that serves the most people in the best way. I might reveal myself as sort of an amateur idea maker, but I think that the current valuation of cryptocurrencies, their current values, are an estimate of the net present value of their future potential. So Bitcoin has a tremendous potential that's reflected in its 600 or so billion dollar valuation right now.
Mm-hmm.
Cryptocurrencies can increase their valuation as their price by showing that they're going to have really real utility. And I think all of them are pretty small potatoes compared to what the potential of the technology is. So it's an interesting how the price of this thing kind of reflects where it could be going. But it's a fascinating. It's a category buster, cryptocurrency and Bitcoin. But the potential for high valuations is real because of the potential for actually delivering. Hopefully we'll get to that before too long.
Fair enough. And I know we talked briefly before we started recording about you having some thoughts on Section 230 of the, what's the actual law that it's a part of?
The Communications Decency Act.
I thought so, but I didn't. I didn't want to misspeak. There's been a lot of discussion, probably prompted by or initially prompted, at least I think in recent history, by the Justin Timberlake, Janet Jackson Super Bowl incident. Or at least the Communications Decency Act certainly was applied there. But obviously more recently across social media networks, or social networks, if you can really call them that: Twitter, Facebook, Google Plus, rest in peace, and a boatload of others.
Orchid,
there have been multiple efforts during the previous administration and now this one, the current one, and debates about reforming Section 230, which, for those who don't know, basically makes it so that a platform like Twitter or Facebook is not legally liable for the things that people like you and I post there. That's probably an oversimplification, but I think is enough for this particular discussion, or people can go learn more about Section 230 if they want. What are your thoughts on reforming Section 230? There have been all sorts of debates about how to do so and whether to do so.
Yeah, when pressed, I've come to the conclusion that there should probably be no change to Section 230. It's possible that there could be ways to improve it, but the possibility of getting them through the U.S. Congress is so low that I don't think anyone should try, because of the likelihood that it will go wrong. My take on 230 is a little abstract and probably unhelpful, but my belief is that 230 short-circuited a conversation that should have taken a little longer, should be still ongoing, which is that question of what the liability of platforms should be for the content that their users post. I think Section 230 arrived at pretty much the right answer, which is that individuals should be responsible for what they do online, whether they're using Facebook or Twitter or some other platform. They're also using, they're using electricity that's provided by their local power company. They're using all kinds of infrastructure, and the infrastructure shouldn't be responsible for what they do. A big part of our theory of justice in the West is that individuals are responsible for themselves, and we hold them responsible. It's a little bit hard to do with anonymity that's available, and that's for the good in terms of free speech, and not for the good in terms of defamation and other wrongs that can be done. But that the rule of 230 is probably right. We got there in this short-circuited process where Congress created a sort of immunity. It gets you out of lawsuits quickly if you're a platform of any kind, not just the big ones but the small ones too. If that rule had been allowed to develop over time, there would probably be more nuance to the rule. The providers would of these services may take a few more steps, because there might be a little bit more legal liability for them out there if they don't take certain steps. So we might have come up with a more subtle rule if cases had been allowed to bat this back and forth rather than Congress stepping in.
Mm-hmm.
I'm a real believer in the common law, which takes the practices of the people and enshrines them as law rather than civil law or European continental style law, where experts decide what the law is going to be and then top down declare those rules. Commonly, you'll see, this decentralization. Cryptocurrency is decentralized. Law that's decentralized, I think, will be better over time than law that is episodically rewritten by experts. Though they are very smart people working very hard to get the right answers, it's very hard to do, especially in these times. So stick with the 2/3 we've got because we've got it. If I could go back and start over, I would not have it.
Fair enough. Okay. I'm going to go back to what Alex used to do, the previous host of this show, and ask you, is there anything we didn't talk about that I should have asked you about or that you do want to mention?
Well, you positioned me to wax tearful about Bitcoin a couple of times, and that was great. And I got to talk about the Fourth Amendment a bit too, and that was great. So I can't think of anything that I really don't cover with you. But it's great to be with you, and I really enjoy talking about these issues. There are so many. There's always so much to learn. Again, that makes me appreciate very much the role I have, the work I do at the American Enterprise Institute. And thanks to you for allowing me to share it with people.
Oh, my pleasure. I don't know what other people's opinions might be about the Cato Institute, where you used to work, and the AEI now, but I think if people are open-minded enough to go read about it, especially if they're a little bit more left-leaning, I think they'll be pleasantly surprised at how reasonable and rational the other side, quote unquote, looks at a lot of these issues, especially some of these really, really modern and fairly new issues that are facing society as a whole, or the world as a whole. So, Jim, thanks so much for doing the work you do, and keep it up. And thanks for spending some time with us here on Private Podcast today.
My pleasure. Thanks, Derek.